के आर्टिकल 21 के अंदर स्टैब्लिश प्रोसेस के अलावा किसी और माध्यम से एक आदमी को उसके जीवन या उसकी पर्सनल लिबर्टी से सेपरेट नहीं किया जा सकता है। लाइफ एंड लिबर्टी, द वर्ड्स एम्प्लॉयड इन शेपिंग आर्टिकल 21 by the founding fathers of the Constitution are not to be read narrowly in a sense monotonously dictated by the dictionaries. They are the organic terms to be construed meaningfully. In fact, the courts have allowed Article 21 to stretch its arm as wide as it legitimately can. The mental agony, expenses and strain which a person proceeded against in criminal law has to undergo, and which coupled with delay may result in impairing the capability or ability of the accused to defend himself. This has persuaded the constitutional courts of the country in holding the right to speedy trial a manifestation of a fair, just and reasonable procedure enshrined in Article 21. Speedy trial from accusation to expiring with the final verdict सारे stages को include करता है. In fact, investigation, inquiry, trial, अपील, रिवीजन एंड रीट्रायल एक्सेट्रा, ये सब इसके स्कोप के अंडर होते हैं. तो सवाल फिर ये उठता है कि क्या कोर्ट एक्यूज्ड के स्पीडी ट्रायल को प्रोटेक्ट और इम्प्लीमेंट के लिए कुछ टाइम बार फिक्स कर सकता है जिसके अंतर्गत एक ट्रायल कंप्लीट किया जा सकता है. इसी सवाल का जवाब पी रामचंद्र राव वर्सेस स्टेट ऑफ कर्नाटका के केस में दिया गया था. हाय एवरीवन, माय नेम इज यश एंड आई विल बी कवरिंग दिस वन ऑफ द लैंडमार्क केस ऑफ द एओआर. इस केस में एक अपीलेंट एक्यूज्ड इलेक्ट्रिकल सुपरिटेंडेंट था इन द मैंगलोर सिटी कॉर्पोरेशन. उसके अंडर सेक्शन 13(1)(e) रीड विद सेक्शन 13(2) ऑफ द प्रिवेंशन ऑफ द करप्शन एक्ट 1988 के तहत आरोपी माना गया था फॉर अमासिंग एसेट डिप्रोपोर्शनेट टू हिज नोन सोर्स ऑफ इनकम. पर क्योंकि 2 साल का एक्सटेंडेड डिले हो चुका था प्रोसीडिंग ट्रायल्स के समय, तो अदालत ने उसे एक्विट कर दिया था फॉलोइंग द डायरेक्शंस ऑफ द एपेक्स कोर्ट इन द केस ऑफ राजदियो शर्मा वर्सेस स्टेट ऑफ बिहार. हाई कोर्ट ने एक रेस्पोंडेंट स्टेट के अपील के अंतर्गत एक्विटल ऑर्डर हटा के केस को दोबारा ट्रायल कोर्ट में भेज दिया फॉर ए फ्रेश डिस्पोजल. ये ऑर्डर देते हुए हाई कोर्ट ने न सिर्फ 55 दिन का डिले रिजेक्ट किया, पर अपील को भी बिना नोटिस टू द एक्यूज के एक्सेप्ट कर लिया. इसके कारण अपीलेंट ने सुप्रीम कोर्ट में अपील फाइल की. सो द इशू इन दिस केस वाज वेदर द सुप्रीम कोर्ट कैन फिक्स टाइम बार्स फॉर द कंक्लूजन और द टर्मिनेशन ऑफ द ट्रायल्स in order to effectuate right to speedy trial flowing from and recognized in Article 21. Basically, this matter was referred to a 7-judge bench to decide the case. As per the court, Article 21 confers a fundamental right on every person not to be deprived of his life or liberty except according to the procedure established by the law. The procedure should be reasonable, fair and just, and therefore flows without doubt the right to speedy trial. The court said no procedure which does not ensure a reasonably quick trial can be regarded as reasonable, fair or just, and it would fall foul of Article 21 as held in Husainara Khatun and others versus Union of India. There can therefore be no doubt that speedy trial, and by speedy trial we mean reasonably expeditious trial, is a vital and essential part of the fundamental right to life and liberty enshrined in Article 21. Now, in the case of Abdul Rahman Antulay and others versus R.S. Nayan and others, the constitutional bench turned down the avid plea of the proponents of right to speedy trial for laying down the time limits as bar beyond which a criminal proceedings or trial shall not proceed. It was expressly ruled that it was neither advisable nor judicially feasible to fix a time limit for the trial of offences. Having placed on the record the exposition of a law as right to speedy trial flowing from Article 21 of the Constitution, this court held that it was necessary to leave the rule as elastic and not to fix it in frame of defined and rigid rule. It must be left to the discretion of the court seize of an individual cases to find out from the totality of the circumstances of a given case if the quantum of the time consumed up to a given point of the time amounted to violation of Article 21, and if so, then to terminate the particular proceedings. However, later on in Common Cause and the Rajdiyo Sharma case, which was heard by 2 and 3 judges bench respectively, the court opined that it could prescribe periods of limitation beyond which the trial of a criminal case or criminal proceedings cannot continue and must mandatorily be closed, followed by an order acquitting or discharging the accused. So in view of conflicting decision, the apex court clarified in the present case that the act of prescribing periods of limitation which would require the trial court to conclude the proceedings and acquit or discharge the accused and applying such discretion to all current and future cases is essentially a legislative function. It is our view that this cannot be accomplished through judicial discretion or fall within the purview of judicial law-making power vested in the Constitutional Court, regardless of how broadly or liberally we interpret Article 32, 21, 141 and 142 of the Constitution. The other reason why the bars of limitation enacted in the cases of common cause and the Rajdev Sharma cannot be sustained is that these decisions of 2 or 3 judge bench run counter to the dictum of the Constitution bench in A.R. Antulay case, and therefore cannot be said to be a good law to the extent that they are in breach of the doctrine of the precedents. The well-settled principle of precedent, which has crystallized into a rule of law, is that bench of lesser strength is bound by the view expressed by a bench of larger strength and cannot take a view in departure or in conflict thereof. Lastly, the criminal courts should exercise their available powers, such as those under section 309, 311 and 258 of the Code of Criminal Procedure to effectuate the right to speedy trial. A watchful and diligent trial judge can prove to be a better protector of such right than any guidelines. In appropriate cases, jurisdiction of the High Court under Section 482 of the CRPC and Article 226 and 227 of the Constitution can be revoked, seeking appropriate relief or suitable direction. So by majority of 6:1, the Supreme Court allowed the appeal and set aside the impugned judgment of the High Court and directed the High Court to hear and decide the appeals afresh after giving notice to the accused respondent before it. So this is one of the AOR cases that we have covered. If you are interested in other AOR cases as well,